Should I defend myself pro se when sued for debt? Brought to you by yourlegallegup.com, your advantage if you're being sued by debt collectors. If you're being sued for debt, do you have a chance at all to fight it? And should you defend yourself pro se? Those sound like two different questions, but for most people, they're really parts of the same question. That's because if you're being sued on an old debt, it often isn't for enough money to justify hiring a lawyer to defend you. You can't afford what it would cost anyway, and frankly, a lot of lawyers taking debt cases are more interested in settling the case than defending it. Still, let's look at the parts of the question separately. First, do you have a chance at all to fight the case? Yes, you do. Your chance of winning is excellent when you're being sued by a debt buyer or a debt collector, and debt collectors are really just a subset of debt buyers, so I'm just going to talk about debt buyers. And a lot of people also win against original creditors too, although the cases look a little bit different than the debt buyer cases. The reason your chances are so good against a debt buyer is that the debt buyers don't, by definition, create the records of the debt on which they're suing you. In most cases, that means they cannot testify to the things that would allow them to get the records of your debt into evidence over your objections based on the rule against hearsay. I'm not saying that they never could, but their business model isn't designed to do that. They would have to train their people in the business of the company selling them the debt, and when 90% of the cases that they file come back as defaults anyway, it just isn't efficient to add the cost of training to avoid a few losses. So debt collectors almost never do that. And that means that you should pretty much always be able to defend yourself and win if you do it right, and you owe yourself the opportunity to do so. Original creditors are a little bit different, since they do create their own records, of course. However, many of them do not keep those records, again for efficiency reasons, and they may not be willing to fight all the way in court either, because that's an expensive and difficult thing to do the way we do it. So your chances of winning are good too. What about doing it pro se, or do you have to have a lawyer? Hiring a lawyer who will vigorously and smartly defend you gives you your best chance to win, of course. It's what we call the gold standard, but it can be very expensive. If you're being sued for $10,000, for example, it's probably worth paying a lawyer $2,500 to defend you. But in debt cases where you're being sued for $10,000, they usually don't have that much. People don't usually have that much to pay a lawyer. That's just reality. And what if you're being sued for $2,000? It could cost as much to hire a lawyer as losing would cost you, or more. And no matter how good a lawyer is, winning is never guaranteed. Keep that in mind when I say we can't guarantee you that you'll win using our materials either. No one can guarantee you victory. There's just too many variables in the process. Your job is just to do the most things that make winning more likely. And our job is to help you do that. But I digress. Back to hiring a lawyer to defend you. We have to consider the nature of the debt defense business as well as the debt collector business when we think about this. People keep telling me the lawyers they're talking to don't want to do anything but settle the cases. I know there are lots of good lawyers out there, but this is what a lot of people keep telling me that they keep finding. I can see why the lawyers do it. Fighting in court is risky and difficult, and it's a tough way to make a living. Settling is easier and quicker, and it looks like you're doing something for your client, even if you really aren't doing as much as possible. You're easing their mind, reducing the risk, making some of their anxiety go away, but you may not be saving them any money. It can be a dubious value proposition all around. That's a big part of why the debt collection business is so big and successful in the first place. Not many lawyers fight it. So for all the reasons I've mentioned, people often have to decide to defend themselves pro se. Debt collection lawsuits are highly standardized the way the debt business is set up. Debt buyers buy hundreds or thousands of debts and file the very same pleadings in them all, as often as not. And the differences between the suits filed by one debt collector and another are very small too. And I might add that this is true of really the whole process of the lawsuit. They do the same things in every case. I know I've said this before, but listen up. From a defense point of view, that means that if you've seen one case, you've seen all of them, more or less. And that's why you can indeed defend yourself. Everything they do is simple, repetitive, and basic, and it's why we can offer the help that we do. We've seen them all and can tell you what to expect and how to prepare for it. It means you can identify the weaknesses of their cases and attack them, and know the strategies that they use and defend yourself against them. It isn't rocket science, but obviously it helps when you know what they're going to do and you have some help preparing for it. We offer that help in various ways and think you can win your case. You should defend yourself from the debt collectors, and if you can't hire a lawyer, you can do it yourself, pro se. We think you'll win, and we will do what we can to help you do just that. Helping people protect their rights is what we do. Protect what's yours, and don't let the debt collectors rip you off. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe, and comment, as all these things help other people find our materials. YourLegalLegUp.com